What happens when a beneficiary is living in an inherited house? Inheriting real estate with other people can be challenging, particularly when one of the beneficiaries wants to stay living in the house. This scenario commonly occurs when siblings jointly inherit their parents' home, which can lead to increased family tension during an already emotional time. It's always preferable for siblings to work out an arrangement that all of the beneficiaries can agree with, such as a buyout. However, under California law, if the siblings can't agree, any of the siblings wanting to sell the house they inherited can use a legal proceeding known as a partition action to force the sale of the house. What happens when one sibling lives in an inherited property and refuses to sell? When one sibling lives in an inherited property and refuses to sell when the other siblings want to, there are several options for solving that dispute. For example, if the sibling living in the home has the financial means, they can buy out the other siblings. However, if the beneficiaries cannot agree on how to handle the situation, perhaps they can't agree on valuation, the sibling who wants to sell can force its sale through a partition action. A partition action is simply a legal proceeding that allows any co-owner of a property to get a court order, either 1, to sell the property, or 2, dividing the property into separate parcels for each owner. Again, where that's possible. But since most residential homes can't be apportioned like this, the most common outcome in these situations is that the court orders the property to be sold and the proceeds to be divided amongst all the co-owners. Importantly, after the petitioning party's fees and costs are paid. This is an important caveat and something that should be discussed with a partition lawyer. This means that siblings that want to sell an inherited property can typically force its sale even over the objections of the sibling who lives in and wants to keep the home. Can I buy out my siblings from an inherited house? Yes, if you and your siblings inherit a house together, you can buy them out if all siblings agree. Even if your siblings have already filed a partition action, there's still time to come to a settlement. The fact that a partition action has been initiated does not mean that the forced sale of the inherited house is inevitable, as long as you and your siblings come to an agreement. The most common settlement is where the sibling who wants to keep the house just buys out those who want to sell it. If this isn't possible, the siblings can pursue alternative arrangements such as renting the property to the sibling who lives there, or allowing the sibling to keep the home in exchange for their share of what other estate property there might be. In some situations, it might be acceptable to all the beneficiaries for the sibling who wants to keep the property to purchase their shares through a payment plan. There are as many solutions to this problem as you and your siblings can provide. You just have to get a little creative. If you're involved in a dispute with your siblings regarding whether you sell a jointly inherited property, you should discuss your situation with an experienced partition action attorney sooner rather than later. Regardless of whether you want to keep the house or sell it, earlier you involved a probate litigation lawyer, the better. Not only can that attorney help you file or defend a partition action in court, but if you speak to an experienced lawyer quickly enough, they can often help you settle those claims sooner for less legal spend and for less emotional cost. Have questions? At RMO, we protect people like you every day. Schedule a free consultation at rmolawyers.com or give us a call or just shoot us an email. Thanks for watching.